And therefore, I'm pleased to introduce our speaker, Dwight Buys. He's a legal advisor from Liberty with more than 12 years of experience with Liberty and Old Mutual. And Dwight will be discussing estates and the devolution of estates. His expertise will provide valuable insights to our process and helping you understand what needs to be put in place to ensure a smooth distribution to your beneficiaries. And as your financial planners, we use this information to advise you on your wills and also to do your estate planning and to discover ways to save on taxes and costs and to prevent any legal complications. We will allow questions afterwards, or if Dwight would allow it during the session. So please raise your hand if you would like to ask a question, and we'll unmute your mic and you will be able to ask questions. Therefore, thank you for joining us again, and let's get started. Dwight, always an interesting subject, estates and estate planning and wills, and I'm glad to see there's a good interest today. So all over to you.
Thanks a lot, Christo, and good afternoon to everyone that is here, and thanks for your time. Yeah, so we're going to be chatting a little bit about estate planning, and if you have questions, you're more than welcome to ask those questions during the session, so we can hopefully try and address them. So what I'm going to do is I'm going to just share my screen. Okay, yeah, so we're basically just going to be talking about marital regimes, the administration process of estates, the value of certain properties in your estate, certain deductions that your estate might be entitled to, and potential claims against the deceased estate. And if you have questions on that, you're more than welcome to ask me during the session again. Okay. Okay, so I'm going to work with an example, practical example, and to try and explain this as best as I possibly can. So I'm going to work with three sisters. Okay, so one is Dolores, then we have Matilda, then we have Hyacinth. They were both born in 1966. They're 58 years old. So the triplets have a very fruitful life, a successful life, and they're all married with kids. No, they're not all married. Two of them are married with children, and we are their financial advisor. So will all three estates look similar? Will they be different in terms of the marital regime? For example, Dolores is married in terms of the accrual system. And then you have Matilda, she's married, community of property. And then you have Hyacinth, who is unmarried and just cohabiting with a partner. So Dolores tells you that she's mainly in charge of the family. Their estates are very similar towards one another. Okay, they each hold an equal shareholding in a company, and on death, the shares is to be transferred to a share trust, or let's call it a business trust. They don't want their spouses or their children to have easily access to the capital because they don't believe that they are capable of managing their own affairs. So in terms of Dolores's current will, her entire estate is bequeathed to a dormant trust. Okay. So how will the assets look like? This is the assets for, let's start with Dolores. So Dolores is married in terms of the accrual system to Frank. Okay. Both parties came into the marriage with a null value. Dolores has 3 major children. Frank has 4 children and 1 is a minor. So apparently Frank went through a midlife crisis and fathered the child, currently 5 years old. He maintains that child out of his living annuity income. They don't talk about the child. Dolores does have a will in place, and all her assets is bequeathed to the trust. Frank also has a will, and he believes that his wife is the sole heir. Okay. Balance sheet. What assets do they have? So Dolores does have a primary residence. The value of that primary residence is 8 million. She paid 4 million for that. Frank has a living annuity, so he's already retired. He invested 6 million and his wife is the beneficiary. Dolores has a car valued at 600,000. She's got investments of 5 million. And the base cost is 3.5 million that was invested. Family business, a third. She owns 33.3% shares in their family business. It's 30 million, a third. She's got an endowment policy. That's your 5-year policies. It's valued at 1.5 million, and the beneficiary is the trust. So she initially invested this product because she wanted protection from creditors, but she doesn't want to use the trust as of yet. She doesn't want to pay independent trustee fees, and she also heard that a trust pays a lot of income tax. Life cover she also has of 5 million. Her spouse is the beneficiary, and she also has a living annuity to the value of 3.5 million. So during COVID, she needed some cash, and she retired from her pension fund. So will the outcomes of her estate planning analysis provide her siblings with a good idea of how their own situations will look like? Let's have a look at it. Okay. So this is the differences. If you married in community of property, all of the assets, regardless of when it was acquired, will form part of the joint estate. All of the liabilities, regardless of who acquired them or in whose name the liability is, both spouses will be jointly and severally liable to each other. The executor will deal with the entire estate, and he will charge a fee on the entire estate. So for example, if the joint estate is valued at 10 million and one of the spouses become deceased, the executor is entitled to charge a fee on that. Let's say the surviving spouse dies 3 years after the first spouse. Again, the executor is entitled to charge a full fee on the last survivor's estate. Okay, so the legally executor can charge those type of fees. All liabilities must be dealt with in the winding up of the estate. So this is particularly dangerous if you marry community of property. So if, for example, the first spouse becomes deceased, you want to ensure that all the liabilities can be settled. For example, a home loan, credit card, overdraft facilities, all of those things, just to make sure that the surviving spouse is not left destitute when these type of liabilities needs to be settled. So the executor, as part of the winding up of the estate, will allocate the surviving spouse his or her 50% share, and the only assets excluded from the joint estate will be through testamentary disposition or third-party injury claims like your road accident fund claims. If you are married out of community of property with the accrual system, both spouses will at all time retain full ownership of the assets. Okay. While they can include and exclude assets from the accrual, this is only for the calculation purposes. Both spouses remain personally liable for their own debt, his or her debt. The executor can only charge a fee on the assets that he deals with. For example, the assets of the deceased spouse, and not a joint estate because they are not married community of property. Only the deceased liabilities must be dealt with if you married out of community of property with accrual. The executor calculates the accrual, which will either be a liability in your estate or it will either be an asset in your estate. Inheritances, legacies, and donations are excluded from the accrual system as well as road accident fund claims. Cohabitation. Both parties at all times retain full ownership of their assets. They remain personally liable for their own debt. The executor only deals with the deceased party's estate. Only the deceased liabilities must be dealt with. And questions we can perhaps ask ourselves, is there a domestic partnership agreement? Is it valid? Is it signed? Is it enforceable? So it's always advisable, if you are just cohabiting with your partner, to consult an attorney and to sign a domestic partnership agreement where you will agree who is responsible for what, who is liable for what type of debts. So in the event of death, it's not gonna delay the winding up of the estate process. Okay, So a spouse. So there's something that we call Section 4Q in the Estate Duty Act. So if, for example, so what SARS is saying here is, if I merely have an immovable property and a vehicle, and in the event of my death, I bequeath those assets to my surviving spouse, SARS is not going to tax me estate duties on it. Okay, it's called a Section 4Q tax deductions. But when the surviving spouse becomes deceased, those assets that should have been taxed in my estate will be taxed in the last surviving spouse's deceased estate. Exactly the same with capital gains tax. And capital gains tax is a real contributor towards revenue for SARS. Okay. And how capital gains tax work? Just to give you a simple example, if I buy a property for R1,000,000 and I become deceased after 10 years, what will my executor do? My executor will obtain a market valuation for the immovable property. So if he obtains a value of 10 million rand, he will first find out what is my base cost on that immovable property. They're going to find out I paid 1,000,000. Now, when I became deceased, it's valued at 10 million. So technically, I made a profit of 9 million. What does SARS want? SARS wants to tax you on the potential profit that you're gonna make on 9 million. That's what it's worth. So unfortunately, for capital gains tax purposes, death is regarded as a deemed disposal. SARS is deeming that you are disposing of this asset at market value. So 9 million, SARS could effectively ask for 18% on that 9 million capital gain. And that's a real danger. This is only applicable if there are capital assets in your estate. For example, shares in a PTY, members' interest in a CC, immovable property. So these are all assets which grow in value over year, or in time, if I can put it like that. Very clever from the receiver. Okay, so what is the definition of a spouse? So a spouse in relation to any deceased person includes a person who at the time of the death of such deceased person was a partner of such a person. In a marriage or customary union in terms of the laws of our country, in a civil union recognized as a marriage in terms of in accordance with the tenets of any religion, or in a same-sex or heterosexual union which the SARS Commission is satisfied is intended to be permanent. Okay, provided that a marriage or a union contemplated in these paragraphs shall be, in the absence of proof of the contrary, be deemed to be a marriage or a union without community of property. So you nowhere see in this definition it's people cohabiting with each other. They will not be regarded as spouses. Okay, so this is basically our customary marriages and our civil union marriages. Nowhere people cohabiting with each other. They are not regarded as spouses. So back to Dolores. Will her estate planning be the same as her siblings' estate planning? Absolutely not, because different marital regimes and different circumstances are applicable. Okay, so their wills may also differ material. So for example, the one sister might bequeath assets to the husband, the other sister might bequeath assets to a trust or to a company or to children. So the rule is, if you bequeath assets to any other individual other than your spouse, it will trigger estate duties, potential estate duties, and potential capital gains tax. Okay, so whatever I don't leave to my surviving spouse will trigger costs. And who's liable to pay those type of costs? My estate. Okay. So this will directly affect liquidity from the executor's fees, the accrual claim, community of property, and potential taxes. So let's first have a look at Dolores. So we had a list of her assets. Okay. So there's assets that can be quickly converted to cash of 5 million. Remember, she's got investments. Less potential liabilities in her estate. Capital gains tax liabilities. Remember, she has a company. She has a third ownership of a company, of that PTY. And as I just explained, if you have members' interest in a CC or shares in a company, that will trigger capital gains tax. It will also trigger estate duties. It will also be subject to executor's fees because she's leaving all of her assets to a dormant trust. Transfer fees, executor's fees, 1.7 million. Funeral cost, 25,000. Estate duty, 3.1 million. There already we have a shortfall of 6 million. Dolores is married in terms of the accrual system. Okay. So, in terms of the accrual system, she has a much bigger estate than that of her husband. So, all the assets accumulated during the marriage, less liabilities, will either be an accrual claim or it will be an accrual liability. Okay. So, in her estate, that's a liability that must be settled towards her husband, 17.8 million. So, and over and above this, an accrual claim will be handled as a preferential creditor. This claim will have preference in the event of her death. Total shortfall, 23.9 million. Very, very, very dangerous. So we've done these calculations for clients where it is possible for the client to actually take out a life policy to make provision for this. The accrual claim will not be applicable if, for example, Dolores is leaving her entire estate to her husband because her husband will inherit the estate in any event. Then this can be ignored. However, Dolores is leaving her entire estate to a family trust, which therefore triggers the accrual claim, and this must be paid to the surviving husband, okay, as a preferential creditor. So let's have a look at the difference between the accrual and community of property from a cost perspective. So, Matilda, assets converted to cash, 5 million, 5 million. Exactly the same. Now, because she's married community of property, everything is divided by half. Capital gains tax liabilities is 3 million. Okay? Here, the capital gains tax liability was almost 6 million. It's 5.9. Transfer fees, executors' fees, funeral costs. If we look at this estate shortfall of 3.3 compared to 23.9 million, it is a massive difference just because of the marital regime difference between Dolores and Matilda. Cohabitation. Cohabitation will also have a different effect. So if we look at Dolores, we've got Matilda, we've got Hyacinth. Also, again, 5 million that I can use for liquidity. Capital gains tax, very similar towards Dolores' capital gains tax. 5.9, also here 5.9. This one is married out of community of property with accrual. This one is unmarried. So Hyacinth is unmarried. So that's why the CGT capital gains tax liability is very similar. Executors' fees, funeral cost, estate duty, very, very, very high. 6.9 million here and 3 million there. Okay. She is unmarried, just cohabiting. So from a 9.8 million shortfall to a 3.3 million shortfall to a 23 million shortfall, marital regime has a massive impact on your estate liquidity, surpluses or shortfalls. So, with regards to winding up of a deceased estate, this is just an indication of the process that an executor has to follow, which is why they also charge a fee. So an executor can charge a fee of 3.5%, and an executor can also charge a fee of 4.025% if that executor is registered for VAT. Okay. So when it comes to reporting the estate, certain notices need to be obtained and submitted. For example, death certificate and your ID, notice has to be given to creditors and debtors. You have to notify SARS of the death of the taxpayer. Death notice needs to be issued, obtain certificates of balances, register the deceased estate, Is there a will? Do I need to sell assets? If I don't have sufficient liquidity in a deceased estate, what can I do? I can ask the heirs, the people inheriting the assets, to pay in cash into the estate. And that's something that we don't want. This is why it's always better to have proper, sufficient liquidity in a deceased estate. Okay. So I don't have to go to your family members and ask them for money because I need to pay myself as an executor. I need to pay creditors and I also need to pay SARS. Okay. I also need to make an inventory, settle all the debt, finalize all outstanding tax returns. Okay, so it's a whole process to wind up the deceased estate, and someone capable needs to do this. Okay, for example, a trust company, most of the banks do this, or qualified accountants and qualified attorneys, and they will charge a 3.5 or 4.0.5% a fee on that, on the gross value of the estate. Okay, so that's just for illustrate purposes. Like we just discussed, the reporting documents that the executor needs to file, there's all your notices. When can an executor actually distribute an estate? Okay, he's only allowed to distribute the estate to a specific heir once he has satisfied the commissioner that provision has been made for estate duty. Okay, an executor can only pay himself after all creditors and SARS has been paid. That's the last step in the winding up process. So who is liable for the payment of estate duty? So the estate in respect of property under the control of the executor, the estate is liable. So the executor steps into the shoes of the deceased. He will wind up the deceased estate. And if the estate is liable for certain properties listed as an asset in the estate, he needs to pay it over to SARS. Okay. Your beneficiaries will be liable in respect of life insurance policies payable to them. For example, if you have a life policy payable to your son or your daughter, okay, and we are busy winding up the deceased estate, we do a calculation. If the estate is more than 3.5 million, the market value of it, or the taxable estate is above 3.5 million, that beneficiary will be liable for taxes on that specific life policy. Okay. If I have to give you an example of a real life scenario, we had a scenario where a son received, I think it was over 18 million rand life insurance proceeds from the death of his father. His father's estate was busy being wound up, and the son did an overseas tour with a couple of his friends. When he eventually came back, another year or two passed, and the executor came to the son and said, "You received life insurance policy payouts. I did my liquidation and distribution account. You are liable for 4 million in estate duty taxes." And the son didn't have anything left. In fact, the last time I checked up with that specific individual, SARS is in the process of actually applying for the detainment of that individual. So he could be arrested. So just be wary of that. Unfortunately, in South Africa, if you have a life insurance policy and you are a life assured, or you have an investment policy and you are a life assured, and you become deceased, if those proceeds become payable to anyone else except your spouse, it could trigger estate duties. That is unfortunately a given. Okay, so the beneficiary will be liable to pay the taxes. The one receiving the proceeds will be liable to pay the taxes on those proceeds. So, give you a quick example. If it's R1 million, okay, if I receive R1 million, I can out of my head do a calculation that the death taxes on that million is maximum 250,000 rand automatically. So the deceased person's executor will come to me and say, "Dwight, I need 250,000 from that million. I need to pay it over so he can pay it over to SARS." That's how it works. So you'll see at the bottom here, it says the executor must do an apportionment to determine how much duty is so payable. That's exactly what they do. So we have customers that have multiple investments, multiple life insurance policies. Soon as that customer becomes deceased, we need to determine which policies is payable to which companies or which children or which trusts, and we need to apportion the taxes between those policies. Policy A liable for 100 Rand, policy 2, 200 Rand, policy 3, 300 Rand. Okay, that is tax law, unfortunately. Okay, so the deceased estate, just another fact for interest purposes, needs to apply for a compliance letter. So this letter is the last step in the administration process, and it serves as confirmation from SARS to the master that all tax obligations of the deceased person have been complied with. This letter can only be requested once all outstanding returns are submitted, assessments are issued, tax liabilities are paid. This is requested prior to the tax obligations being fulfilled. If it is requested before this, it will not be issued. Okay. So how important is it to choose the correct executor? So I still see many clients that nominate their spouse or their brothers, sisters, or kids as executors. Your executor needs to be a qualified person that has experience in winding up deceased estate. So what is the financial impact on dependents of a delayed winding up estate? Excuse me. So determining the fair market value of your estate. So there is legislation for this. It's contained in Section 6 in the Administration of Deceased Estate Acts. It explains that an appraiser needs to be appointed. If, for example, a client becomes deceased, that client has assets, businesses, vehicles, immovable properties, whatever the case may be. Your executor needs to appoint an independent valuator and pay the cost to that independent valuator. Okay, why is SARS doing this? SARS is doing this because it's collecting a lot more revenue on your higher type of market valuations of properties in a deceased estate. Okay, especially business owners and immovable properties, if there are immovable properties. The higher the value of your property in your deceased estate, the higher the potential tax liability to SARS in estate duties and capital gains tax. They are checking values in deceased estates. Okay, that is unfortunately a given. So what we did years ago, not we, what I know of what some people did, some executives did, especially with the business owners. So they deflated the value of businesses in a deceased estate. So let's say, for example, the business is actually worth 20 million, but now the business owner becomes deceased, it can be deflated to 5 million. That has been done in the past to reduce capital gains tax and also to reduce potential estate duties. Now, SARS is checking the values of businesses in deceased estates. Okay. And this also goes for all the other assets. They want to make sure that all your assets are in your estate. They call it a liquidation and distribution account at fair market value. Okay. So how do they determine the value of property in a deceased estate? Your primary residence. Okay. So if it is kept, the estate agent value or the municipal value will be accepted. If it is sold, fair market value will be accepted. Primary residence will attract capital gains tax. Okay. Effectively payable at 18%. Estate duty levied at 20%. Your car, if it's kept, dealer valuation, sold fair market value valuation, it's not subject to capital gains tax. It is subject to estate duty. If you have unit trust, or what we call in financial terms LISP investments. If it is kept, the actual value as at date. If it is sold, the actual value as at date of death. Unit trust investments does attract capital gains tax. It also does attract estate duty. Cash. If it is kept, the actual value as at date of death, cash will only attract estate duty. Family business, and this is where they really check the value of your family business or your business interest. If it is kept, valuation provided for by an auditor and accepted by SARS. This is the only one that has to be accepted by SARS. If it is sold, valuation by an auditor and accepted by SARS. The state cannot be wound up without SARS accepting this valuation. Family businesses will attract capital gains tax at 18%. It will attract estate duty levied at 20%. Unfortunately, that's how it is. Endowment policies will not attract capital gains tax. It could be subject to potential estate duty, depending on the value of the estate. Life cover, like I mentioned now with the son, the small boy that didn't have enough money for his father's deceased estate, life policies could attract estate duties depending on the value of the estate. Okay. So there we see clearly most assets, if I can go back here, most assets will attract estate duty. And many clients are unaware of this. Okay. So all of these tick boxes will be empty if your entire estate is to be inherited by your surviving spouse. But when your surviving spouse becomes deceased, all of these tick boxes will be active again. So you're just delaying the process. So if I die and my entire estate is bequeathed to my wife, there will be 0 estate duty and 0% capital gains tax. When my spouse dies, when my wife dies, there will be capital gains tax and there will be estate duty. Okay, so you're basically delaying the inevitable. And just to make sure that I'm not talking just for the sake of talking, there's the email address for the valuations, estate share valuations at sars.gov.za. They are checking it, okay? So SARS wants to make sure that we list all of our assets in our estates at fair market value to make sure they can recoup as much revenue as possible, okay? So when it comes to estate planning, and if you are a business owner, it goes hand in hand with each other. Okay. Business owners, business owners, all business owners, whether it be a sole prop, whether it be a CC, whether it be a PTY, your business interest will form part of your deceased estate. This is why we always encourage business owners to have a product which we call a buy and sell policy. Okay. This is basically a policy that will become payable to your estate in the event of death. Okay. That policy is going to help to pay for capital gains tax. It's going to help to pay for estate duties. It's also going to pay for the executor's fees. And if there is a surplus, the residue is becoming or will be payable to the residuary heir, which is normally the surviving spouse. Okay. These type of policies ensure that the business can continue. So if, for example, you have 50% business interest and I have a 50% business interest and I become deceased today, you have a policy on my life. I'm deceased today. You will receive the proceeds of that policy. My 50% business interest forms part of my estate. You need to pay that policy into my estate. My executor will transfer my business interest over to you. So I'm basically switching the business interest for shares. It's merely a swap. So instead of My estate now owning a business interest, my estate is owning a life policy, which is cash. So my estate will need the cash. You are still alive. You need to continue to pay salaries. You need to continue to run the business. You need to continue to work. And in a delayed estate, it's going to be very difficult for you, you're still alive, to continue to run that business, while half of the ownership of the business is tied up in a deceased estate. Once you have these type of products in force, it's going to ensure that there's a smooth takeover. My estate can be wound up quickly. You don't have to deal with my family, which is my wife and my kids. You are the sole owner of that business now. You can continue with business. I'm protected because there's cash in my deceased estate. I can pay SARS, I can pay my executor, and there's a surplus in my estate. My family can use that to do an investment to pay for their maintenance needs, for example. Okay, all business owners must have this specific product in force. Okay, we also give you an agreement. So whether you be 2 partners or 3 partners or 15 partners, we will supply you with an agreement which is going to create an obligation for the deceased person to sell, and it's going to create an obligation for the person still alive to buy your business interest. Okay, so many business owners do not want to deal with family members in the event of someone's death. Okay, you would rather pay cash into their estate, buy their business interest, you carry on without dealing with a spouse or son or daughter. Very, very important. So why is the value of property important? Very important. It's important because of the executor's fee, that 4.025%. Most of them are registered for VAT. Capital gains tax, 18%. Estate duty, 20%. Accrual claim, very important. That accrual claim is a claim that many people ignore until someone dies. So if you married, in terms of the accrual system, you need to know exactly, will there be an accrual, will the accrual claim be an asset or a liability in your estate? Very, very important. Do those calculations now to make sure that no one will be in trouble in the event of death. So material, because drives how much money will be needed to pay for the winding up of the estate, as well as to pay SARS, and accordingly how much is left for distribution to your beneficiaries. That's exactly why the value of property is important in a deceased estate. So once we make a list of your assets in an estate, are you entitled to certain deductions? Absolutely. This is where it's a good thing to have debt. The more debt you have, the less estate duty you're going to pay. But the more debt you have, the danger your estate is going to be from being an insolvent estate. Okay, so it goes hand in hand with each other. That's unfortunately the problem. I always say it's better to be overinsured than underinsured. Once there's money in the estate, I can pay all my creditors, I can comply with SARS, I can pay myself as an executor, and the residue of the estate I can distribute to the wife, to the kids, to the trust. Everyone can go on with their lives. Once there's a shortfall, an estate shortfall, now I have to go ask for money from the spouse or the kids or from a trust. And once they don't have it, then I need to start selling assets. What assets am I firstly going to look at? Business interest number 1, because I can get a lot of money there. Immovable property number 2, I can also get a lot of money there. Problem is, as an executor, I need to sell those assets on auction. So your property can be worth 6 million. On auction, how much am I guaranteed 6 million purchase price? Absolutely not. I might get 4 million for it. I might even get 3 million for that property. And I might take that bid because I need cash to pay myself and to pay creditors and to pay SARS. So there's the risk you run if there's not sufficient liquidity in your deceased estate. So maintenance, there's also maintenance claims which can be lodged against a deceased estate. Maintenance will be deemed in income in the member's hands. Okay. and the member is liable for that tax. You pay income tax on it. You pay the after-tax amount to the person claiming the maintenance. It's usually an ex-spouse. So the member pays the tax, doesn't come out of the maintenance amount, so a further amount must be taken. It's a tax-on-tax approach. Unfortunately, that's how it works with maintenance payments. So your allowable deductions, number one will be your accrual claim, if it is a liability, but it can also be an asset in your estate. This is only applicable, your accrual claim is only applicable at dissolution of the marriage. So if I get divorced, it could trigger the accrual claim. If one of the spouses become deceased, it could also trigger the accrual claim. Okay, so where the deceased had a larger accrual than the surviving spouse, then the estate must pay half of the difference between the value of both accruals. This is a liability in a deceased estate. He must pay it. Where the deceased have a smaller accrual than the surviving spouse, then the surviving spouse must pay half of the difference between the value of accruals to the deceased estate. This will be an asset, either an asset or a liability, which have to be paid. So again, with our three sisters, with Dolores, let's look at her accrual, massive accrual claim. We did a calculation, 53 million. Frank's estate is only 6 million. We deduct our liabilities. Then we come to an accrual. What's left? 35 million divided by 2, 17 million accrual liability. Okay. So that's the risk people can run with an accrual claim. So unfortunately, there are still a lot of court cases challenging legislation and stuff. So this was a court case held a couple of years ago. Parties were getting divorced. There was a living annuity involved in this court case. So does a living annuity form part of the estate for accrual system? Does the principal extend to death? On Dolores' death, her living annuity pays to a beneficiary outside the estate, not to her husband. On Dolores' death, Frank's living annuity is still in existence and the annuity stream can be valued. So the bottom line is, with regards to this case, this Montanari case, living annuities do form part of accrual claims. So what is a living annuity? So if I retire at age 60, let's say I've got R1,000,000, I use that R1,000,000 to buy an income for myself. That's a living annuity. Okay. So that specific annuity also does form part of the accrual system in terms of that court decision. So another example here with Frank and Dolores, where Frank is the first dying, the claim is calculated as follows. So remember, with Dolores' estate, it was a liability. So with Frank's estate, it is unfortunately it will be an asset in his estate. Okay. So like I mentioned before, there's no need to make provision for the accrual claim if your spouse is the sole heir of your estate. Frank has bequeathed his entire estate to Dolores. No need to provide for the physical payment of the accrual claim. Okay. So can you waive your right to claim the accrual? Absolutely, yes, you can, but then you pay donations tax, 20%. That's our tax rate. So imagine if the accrual claim is 17 million and I waive my right to claim this. So let's say Dolores is the first dying spouse. Frank needs to pay 20% on 17 million. You're looking at 3.3, 3.4 million that has to be paid within the same financial year. Very, very dangerous. So possible advice for you and possible solutions. What can we talk about? Estate liquidity. Can't talk about this enough. Make provision for your executor's fees, liabilities in your estate, capital gains tax, estate duty, potential accrual claim. Okay, there has to be life insurance proceeds to make provision for these type of scenarios. If we cannot obtain life cover for a client, then unfortunately the only other solution is to do an investment for these type of clients, because these costs need to be paid in a deceased estate. Okay, it's always cheaper to rather do life cover, pay a premium for this, make sure policy is payable to your estate to pay all of these people. By these people, I mean the executors, SARS, and creditors, debt. Okay. If we can't get life cover for the client, unfortunately, we need to invest money, or we need to ask the people inheriting the estate to pay money into the estate. Okay. From a liquidity perspective, your executor will convert assets into cash. If you have investments, for example, unit trusts, he will cash it in because he needs to get his hands on cash to pay potential creditors. Like I mentioned, he will also advertise the deceased estate. Okay, he must do that. He needs to pay capital gains, estate duty. So how to deal with the accrual claim specifically? Very simple solution. If there is an accrual claim, take out a life insurance product to make provision for that. That's going to be your cheapest way of making provision for estate duty shortfalls or estate liquidity shortfalls and accrual claims. One thing we also cannot forget is dependent provision. Okay, so if, for example, the husband is the main breadwinner of the house, earning 30,000 Rand a month, we can make provision for that 30,000 Rand a month for a specified period of time. So I can take out life cover on my life today to make sure that my family will still receive 30,000 Rand for the next 10 years or 20 years or 30 years, depending on affordability from my side and depending on the need of my dependents. Okay, that is really, really, really important. So over and above the mere fact that my estate needs to be liquid, there's my first problem. Is there enough cash in my estate? Okay, to pay SARS and executor and creditors and all of those things. That's my first problem. My second problem is my family is now sitting with a loss of income. The 30,000 Rand I was earning is gone. So I need to make sure that I've made provision for that 30,000 Rand to continue for a specified period of time, depending on my wife's earning ability and the ages of my children. Okay, so we do give life cover for clients who need this type of cover. Very, very important, and something that we still, or many clients still ignore in today's economy. Okay, so unfortunately, we need to make provision for this. So in Dolores's scenario, she was the breadwinner. Where will Frank get the money to live off immediately after her death? Because she's bequeathing all of her assets to a trust. How long will it take to get to the point where the executor can distribute? That's the other thing. How long does it take for an deceased estate to be wound up? It's supposed to take 6 months. I've seen estates being wound up in 7 years. Some 5 years, some 2 years, very few in 1 year, to be totally honest with you. Okay, so dependents might need capital. They might need liquid capital to survive, but the executor is not done with finalizing the estate. He can't do it. He's still busy advertising. He's still busy lodging documents. He's still busy looking for money. He's still busy paying creditors. That's the thing. But your family still needs to survive. If there was a life policy payable directly to Frank, he would not depend on the executor to wind up the estate quickly. He can tell the executor, take your time. I received my life insurance payout. I invested it. I'm already receiving an income of 30,000 Rand a month. Life products can take between 2 weeks and 4 weeks to pay out just like that. Okay, that's going to make sure that your people still survive financially in the event of your death. And talking about that, just remember retirement products. Retirement products. I'm talking about a retirement annuity, also talking about a pension fund, also talking about a provident fund. If the main member of that retirement fund becomes deceased, the trustees, first of all, determine who will receive a retirement benefit. You don't, they do. And then they have 12 months to actually start making payments. So they legally have a year to trace people, to look for legal and factual dependents, and only after the 12 months can they actually make a payment. Okay, so that's what many clients are also still unaware of. Don't depend on retirement products to support your family immediately after your death. They do take 12 months to start making a distribution. So you can nominate beneficiaries. However, the trustees don't have to adhere to that. That's just an indication that you would have liked certain people to receive a benefit. With a life policy, it's different. If you nominate a beneficiary on a life policy, they have to pay the beneficiary. If you nominate a beneficiary on a retirement product, it's a different story. The trustees decide who will receive your retirement benefits. Usually, it will be your surviving spouse and your children financially dependent on you. Problem there is that 12-month period. Sometimes they can take even longer than a year to start making payments of retirement products. That's exactly why we do comprehensive estate planning for the clients. We show the client today, Mr. Client, in the event of your death, we will need 2 million to cover all the costs. We will need another 2 million to provide for your family immediately after your death. Not after 12 months, not after 24 months, immediately after your death. It shows the customer exactly what will happen to his assets, who will inherit his assets, how his assets will be distributed, and will his estate plan be enforceable while the client is still alive. It also shows you where your life policies will pay, who will receive the benefits of your life policies and your investments. Will there be tax on your investments and your life policies? We show the client today while he or she is still alive. Very important to start doing estate planning if you're in such a position. Okay. Any questions for me? Something that perhaps was not clear?
Thanks, Dwight, for highlighting how expensive it is to die. It's quite shocking to see how costs and capital gains could have major implications if you don't plan for it properly. While I wait to see if there's a question or two, it's just a note to say to people it's therefore important to check that your wills are clearly outlines your wishes, and it's also very simple that we can distribute your assets, and also to consider these potential tax and cost implications, and that's what we do when we do the holistic planning. And also to have all your documents and power of attorneys and other necessary documentation stuff accessible to your loved ones in order to also quickly start the process in the event of death. So that is also why it's important to have somebody like us at Prospect, where both the accountant and the financial advisor can work together to do the taxes and everything. Maybe one of the questions I've got here is, we've seen there's quite a big difference on the costs in the different marital regimes. Is it possible to change your marital regime then?
Yes, Crystal, absolutely possible to change your marital regime. However, I have heard and seen that it does cost quite a lot of money, and over and above that, you need approval from a high court judge. You need to submit valid reasons for why you actually want to change your marital regime. So it will not automatically be granted. Even if you pay your attorney's cost or your advocate's cost, you need to submit valid reasons for applying to change your marital regime.
And I expected it quite a costly exercise as well.
Yes, absolutely. I mean, at the last figures I saw, it can range between between 100 and 200,000 rand, high court applications. So,
All right. The other question that I've received is regarding the use of trusts. I still see a lot of people think that trusts are one of the best ways to get past these costs and everything. Is it advisable in all instances and all estates to start using trusts? And what are the tax and cost implications of doing and managing trusts?
yeah, don't get a trust if you don't know how it works. That's that's the first thing that I would do. Understand how a trust works. Trusts are usually more beneficial for more beneficial for your people with your larger type of estates. Okay, so how does a trust work? A trust works is how it works is where you have trustees that administer assets on behalf of beneficiaries. So, who are the trustees? Usually, I see a husband, he's a trustee, a wife is a trustee, and an accountant is a trustee. So, the accountant is merely there to actually run the trust, to be the independent professional trustee. So, your trustees administer your assets on behalf of your beneficiaries. Who's the beneficiaries? What I see in practice, I see husband, I see wife, and then I also see the children. They can benefit. They are the only ones that can benefit from the assets in a trust. Okay. So that's in a nutshell how a trust works. So trustees administer assets on behalf of trust beneficiaries. Your biggest problem is it's nice to have a trust. A trust can cost you 10,000 Rand. How do you get assets into a trust? That's the biggest problem we're sitting with now. So you can donate assets to a trust, then you pay 20% donations tax, and then you also pay 20% capital gains tax. Or you can sell assets to a trust, but now you're sitting with a loan account. And once there's a loan account between the client and his trust, you need to start charging interest on that loan account. We also don't want that. So that's another conversation that we can have specifically. So that's your problem. How do you get assets into the trust from a tax efficient manner? Another thing people need to be wary of is a trust pays 45% income tax. On top of that, a trust pays 36% capital gains tax. A company pays 22.5% capital gains tax. A company pays 27% income tax in comparison to 45% income tax. Okay, so there are ways how we can get around paying a lot of taxes, for example, in a trust. So what a lot of people are doing or clients are doing is all the undistributed income in the trust, they're distributing it to a beneficiary. So then the tax liability moves from 45% to the marginal rate of the beneficiary. And usually that's like a housewife. So what I see is a housewife is on a 10% or 9% income tax bracket. Then we shift it from 45% to 9%. Very, very clever, totally legal to do that. So it will depend from customer to customer. So many people sit around a braai and they hear how lovely a trust is. But before you even think about a trust, we have to sit and do a proper estate planning analysis for you and advise you as a client. Is it going to be worth your while to establish a trust? And also advise you how we are going to move assets out of your personal name into the name of a trust. How much money is it going to cost you? So what I'm trying to say is before we even do that, we need to do an estate plan for you, and you must understand exactly how a trust works as a client.
Thank you, Dwight. Also, a question I've received is regarding living wills. What is the benefit of a living will, and is it enforceable?
Yeah, it's definitely enforceable. I barely see it, but I know it's definitely enforceable. So that's basically I've seen very few of them. So if, for example, the client, is laying on a deathbed and he can't make decisions for himself, then they refer to a living will. For example, where machines need to be switched off and those type of things. So I barely see it in practice, but I have seen one or two a couple of years ago. A living will is absolutely enforceable.
Okay, and but you can't state there that if you're not compos mentis, that somebody else can take over your financial affairs.
Yeah, so with regards to that, I know you need to appoint a curator. That is gonna be legal and binding. And in terms of a living will, I haven't seen that being
I
a
don't
success
don't
as of
believe
yet.
that's enforceable then. Yeah.
Mm-mm.
Okay. All right. Um, is there any other question that you might be able to see? To me, if you can maybe assist you in the chat box. Otherwise, I think that is the full amount. Thank you, Dwight, for this informative session and for everyone attending. I hope you find this invaluable. I hope you can see the benefits of using the combined expertise of Spectra Financial Services and Prisma Accountants in the financial plan, and to consider all this when we do the financial plan. But we also then ask you to maybe set up a meeting and discuss your individual uh, situation and maybe make some minor changes to that. Also, we would like to invite you to our next webinar. We will be sending out invitations soon. It's on the 7th of August, also with Dwight co-hosting, and the topic will be aimed at more like estate planning for businesses, a bit more into how businesses are valued and how to make that business can carry on after the death, because a successful business can become a nightmare for the surviving spouse and partners and shareholders and the employees if we didn't reach a plan and implement it. So please look out for an invitation that will be sent out soon. Thank you, Dwight, and thank you, everybody else. If there's no other questions, that'll be the whole webinar for today. Thank you.